Good afternoon, everyone. We're about to start with the lectures. So I will be really thankful to everyone if you can turn on your camera, at least in the beginning and the end of the session. Good afternoon. My name is Ines Miranda from BK21 Center for International Migration and Diaspora Innovative Talents. I would like to welcome everyone attending this diaspora forum and appreciate your interest in this event. Aguliani, I hope I pronounce it correctly, as our special speaker for today's seminar. She is a lecturer of law at the National University of Ireland in Galway, where she teaches European Union law, international migration law, and international and European migration law. She is a research fellow in anti-trafficking and policy for the British Institute of International and Comparative Law, and she has served as a senior legal advisor for the United Nations Special Reporter on Trafficking in Persons. For today's lecture, titled as Transnational Trafficking in Human Beings, Risk, Responses, and Responsibilities, we will be presenting on some of the key aspects in relation to human trafficking today, including common misconceptions on the term, how the term has been defined and how it does evolve, what are the causes and risks affecting human trafficking, and what is the role of the states regarding the issue. Graduate students at the Department of Global Diaspora Studies, researchers from the Center for Global Diaspora Studies, and other scholars interested in the topic are participating today in this seminar. And we especially hope this lecture can serve as inspiration to generate new research ideas for the future. And before starting with the lecture, I would like to invite Professor Kim Kyung-hak, Director of BK21 Center for International Migration and Diaspora Innovative Talents and the Center for Global Diaspora Studies, to welcome this seminar. Professor Kim Kyung-hak. The mic is not on, Professor.
Yeah, hello, I am Professor Kim Kyung-hak, in charge of the Department of Diaspora and Research Center at Transnational University. Today we invited Dr. Naomi Maguliani, lecturer of the School of Law at National University of Galway, Ireland, as a guest speaker for Diaspora Forum on titled Transnational Trafficking in Human Beings, Risk, Responses, and Responsibilities. As people-to-people exchanges between countries have been active since the end of the Cold War, the issue of human trafficking is emerging as a global problem. The main forms of the human trafficking are the sexual exploitation of women and the exploitation of children in the labor force. Geographically, the scope of the traffickings varies from the former Soviet Union and Eastern Bloc countries to Western countries, from Nepal and Bangladesh to India, from Myanmar and Laos to Thailand, as well as cross-continental trafficking. The most fundamental background to the prevalence of the human trafficking is absolute poverty and the gap between the rich and the poor. I think international cooperation is necessary to deal with transnational organized crime. In fact, the average Korean knows little or no interest in the human trafficking situation of Koreans. However, there are people who are victims of human trafficking while traveling from Korea to another country, And there are cases where victims of human trafficking are transferred to other countries via Korea, or the victims of the trafficking in Korea. According to a report from the US State Department, some Korean women enter other countries on tourist work or study visas and are forced to engage in prostitution through massage parlor, pubs, restaurant, or internet prostitution companies. Actually, Korea is also not free from the stigma, being a country of origin, transit, and destination of human trafficking. Therefore, in line with the global trend of responding to human trafficking, it seems that the relevant law should be revised in Korea. I hope that today's Dr. Naomi's lectures will help to understand the current situation and problems of transnational trafficking and how it is related to the prevalence of the international migration. I would like to express my deepest gratitude to Naomi for a valuable lecture today, and I hope that this lecture will serve as an opportunity to develop academic exchanges, National University of the Island Korea, with our department and research center in Jeonnam National University. Thank you very much.
Thank you, Professor Kim Kyung-ha. And the lecture will be soon start. We will have 1 hour lecture and then 20 to 30 minutes for questions from the audience. I will pass now the turn to Noemi Bakuliani to do the lecture. Thank you very much.
Thank you so much. I would just like to start by sharing my screen again, if that is all right.
Yeah.
And I hope you can still see that.
We can see it.
Perfect. Amazing. Thank you. And thank you very much for the kind introduction and for having me, even if only virtually. It really is a great pleasure to be addressing you today, in particular as part of the Global Diaspora Forum lecture series. And I look forward to an interactive and engaging discussion throughout the lecture, but also at the end of our time together. So having researched and worked on in different capacities and through different institutions on trafficking for the past now 8 years, I am very delighted to be engaging in a conversation about human trafficking, its inception, its current manifestations, and understandings. Now, the focus of today's lecture, I should say, is transnational trafficking in persons, which is a specific form of trafficking, albeit not the only one that exists across the globe. We will be looking at definitional issues, but we will also go beyond what is normally known as the letter of the law and look at risks of, responses to, and responsibilities for trafficking in persons. Now, in the last 10 years in particular, there has been a sort of global awakening with regard to trafficking in persons. And increasingly, trafficking and traffickers have made headlines in newspapers across the world. The language of human trafficking, or as it has become known in the Anglophone world, modern slavery, has become used almost daily among government officials and international institutions alike. The general public as well has today a higher, yet not complete nor perfect, awareness and understanding of what human trafficking entails. However, oftentimes trafficking is discussed quite superficially, and the language of trafficking is misapplied to situations that are not actually trafficking, or the other way around. So situations that are situations of trafficking are misidentified as situations of, for example, human smuggling or exploitation. So there are myths and misconceptions around the phenomenon that have proliferated as part also of strategic narratives deployed by key stakeholders. And here I refer not only to governments or states, but also to academics, researchers, individuals working in the civil society sector, journalists, policy advisors, etc. So every stakeholder has their own strategy, their own narrative, and they bring that to the table. And all together, these informs the way in which we think about trafficking, how we conceive the phenomenon, and what we think the phenomenon to be. Now, I've added some examples taken from, these are snapshots from the World Wide Web. So you can see they span across different jurisdictions, different regional areas. We have institutions such as the International Criminal Court talking now about enslavement and trafficking. We have trafficking mentioned in the context of channel migration in the UK and France. We have illegal migration as a term used alongside trafficking and organized crime in Morocco. We've had mentions of human trafficking and criminal groups in Colombia, and this goes on and on and on. So again, increasingly, we're seeing trafficking being part of almost the mainstream media and the mainstream narrative. Another big area that has influenced also understandings of trafficking is surely the area of quantitative data. So not only qualitative analysis, qualitative narratives, but also quantitative data. And we will come back to the issue of data collection, which data is collected, which one is not, who decides which data is collected. But increasingly, we're also seeing these sort of exercises being done. And in particular, exercises of mapping, so understanding what the trafficking routes are. So where do trafficked persons come from, through which countries they travel or they're made to travel, and where are these individuals exploited in the end. Now, clearly, I will share the link where you can find this map. It's an interactive map later on. And there's always a disclaimer at the end, which says this map or this exercise is based on available data. So the data that either governments, civil society organizations, international monitoring mechanisms have been able to collect and to share. And this is a disclaimer that makes sense since it is almost impossible to fully understand and grasp how many people are trafficked at any given time and which pathway they follow in their journey of human trafficking, their human trafficking experience. But what we can see and grasp already, even through a partial data set, is the complexity of it. It's the global nature of trafficking. It is the links between East and West, North and South. It is the link within the East, the West, the North, and the South. So there's no one route, there's no one journey that trafficked persons and traffickers embark on. But on the other hand, or conversely, it is very much a complex exercise of mapping and understanding what drives human trafficking and what routes are taken by, again, traffickers and trafficked persons alike. But because I mentioned myths and stereotypes, misconceptions, and understandings of trafficking, I would really like to start with a bit of an interactive exercise, which is clearly not mandatory and open to anybody who would like to participate, which will not take more than 5 minutes of our time, really. And I would like to ask you all to go to the link that you see in the slide, and I will also paste that in the chat to everybody. There you go. I hope you can copy and paste that. You will have the possibility, once you open that link, to enter either anonymously or not, as you prefer, one or more words that you associate with human trafficking. It is important that this is an unfiltered sort of exercise, one where you give yourself the liberty and the flexibility to submit whichever words come to mind when you think about the phenomenon of trafficking. Now, this exercise will generate a sort of mapping that I would then like to address in 5 minutes' time to look at sort of the preliminary findings, if that is okay. And let me know if the link is not working, and I will try and fix that.
I think it's working.
Okay, great. I can confirm it is. And whichever words come to mind when you think of human trafficking, there's no right or wrong, everything is anonymous. Feel free to write, again, more than one, and just press entry for every word or combination of words that you would like to add.
Maybe we can have not sure many people is right.
Yes, so I'm looking at the word cloud forming in the meantime as you write, and I see you can keep adding to that even as we go along, but it's a fair enough point. And I think this is a really interesting exercise to make at the beginning of this lecture. And now I can see some, again, the words get bigger the more mention they have. So I'm just trying to identify a number of them that are quite big in this word cloud. And surely I can see women, I can see deception, children, exploitation, fraud, transporting, movement, force, coercion, exploited, migration, brokers, lies. So there's so many words that pertain to the domain of trafficking in persons, and all of these words, one way or another, are part of that context and of that word. Now, what was interesting to me, and what I think will become interesting as we go along in the context of the lecture, is why we think about these words when we think about trafficking. What informs the way in which we understand what trafficking is. And before joining today, so before this exercise, I had compiled a list of common myths and misconceptions around human trafficking. So not knowing what you would have written actually in the context of the word cloud. So let's see if some of the words that you've added in that context resonate with what are, again, common myths and misconceptions on the phenomenon. The first myth and misconception is that trafficking requires movement. It doesn't necessarily require movement. It surely can engage with or include movement, but it's not a requirement for the trafficking definition, legally speaking, to be met. In particular, there's no requirement of a movement across borders. So as I said in the beginning, transnational trafficking is one type of trafficking. It's not the entirety of it. Indeed, the facts or the argument that trafficking requires a cross-border movement is factually incorrect. The irrelevance of movement has been enshrined in regional anti-trafficking instruments, such as the Council of Europe Anti-Trafficking Convention, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, very long name, among others. And it has been upheld in the jurisprudence of regional courts, including the European Court of Human Rights and the Inter-American Court of Human Rights. Now, the second common myth is that trafficking requires complete lack of consent to the exploitation. Again, this is a myth, although a quite well-established one. It is indeed sufficient that the consent of a trafficked person is vitiated. In other words, it is not free and informed. We will come back to the issue of consent because it is a crucial one. Now, the third myth or misconception is that trafficking has a higher threshold of exploitation than, for example, forced labor or forced prostitution. This, again, is incorrect. Indeed, the trafficking definition does not mention a minimum threshold of exploitation. On the contrary, forced labor and forced prostitution might be outcomes of a trafficking process. But the distinction is one of nature of the process rather than threshold of exploitation. Fourth myth and misconception is that trafficking primarily relates to sexual exploitation. So there are both historical and legal underpinnings to this misconception, which is systematically reinforced by partial data being collected and shared on the numbers of identified trafficked persons. Now, more recent estimates show changing patterns of recognition. And I do say recognition for a reason. So it's not patterns of exploitation. I would argue these are patterns of recognition of the exploitation, which are interesting to analyze and to unpack. Indeed, in the last few years, and in particular, following the emergence of the concept of modern slavery, numbers consistently show that the most widespread form of trafficking is trafficking for the purpose of forced labor. Yet, we have state policies vis-a-vis trafficking that continue to maintain a sort of special relationship between trafficking and sexual exploitation, which can be understood and explained by looking at the lens through which states frame trafficking, oftentimes grounded in morality, religion, and patriarchal constructs of agency and victimhood. And we will again come back to this. These are just snapshots at the beginning. And the last myth I wanted to touch upon is also connected to the one we just discussed, is that trafficking primarily concerns women and children. Now, as we will see, since its inception, trafficking has been considered a gendered phenomenon, yet gender has been highlighted mostly, if not exclusively, with respect to women and girls. So gender has been reduced essentially to biological sex or conflated with it. And this has allowed for a reductionist approach to the complex power dynamics behind trafficking. So gender has been strategically understood and deployed as relevant only to women and girls, thus rendering women and girls the only subjects of a gender analysis of their risks of being trafficked, their vulnerability, and their victimhood. This understanding has further contributed to the creation, even in academia, of a body of literature focusing on gender inequalities as one of the root causes of trafficking in persons, which is, I'm not contesting, but which has failed to include gender dynamics, for example, between men, and more broadly, gender dynamics between the masculine state, the patriarchal state, and the foreign masculine population under its jurisdiction from the discourse. So all these gender dimensions have been sidelined, and only one has been looked at and unpacked in detail. The one concerning, again, gender inequality, but with gender conflated with biological sex. We will come back to some, if not all, of these myths. But in the meantime, I think there is a question that begs asking, and it should be asked, which is what informs these myths and stereotypes? There are several factors that have, over time, contributed to their establishment and maintenance. First and foremost, we can link myths and stereotypes to past and present laws, policies, and practices. Indeed, as we will see, the history of the international anti-trafficking framework has been heavily fragmented and heavily charged with narratives. A gendered one, a criminal one, a human rights one, and so on and so forth. Secondly, lived experiences, at least those that are picked up and replicated in mainstream media and communication, have also contributed to the creation of misconceptions. So images of trafficked women and children in chains, severely exploited, have dominated the public sphere in the early 2000s, but also in the 2010s. And we still see that in the 2020s, being one of the main features of anti-trafficking communication, again, in the mainstream environment. Another factor that contributes to the maintenance of stereotypes, including in research in the world of civil society organizations, is positionality. And since the inception of the anti-trafficking system, the narrative has been quite dominated by white, cisgender, Western women in particular, that pushed for an agenda that they believed in and were interested in supporting. More recently, this particular positionality has been challenged, for example, by sex workers-led organizations, migrant-led trade unions, especially in the so-called Global South, a term I'm not a huge fan of, but that I think we can all understand and relate to, who bring to the table different perspectives and direct lived experiences of what are really the root causes, what really are the problems in the context of a lived experience of trafficking. But in this web, which is complicated, how do we find clarity amidst the confusion, the overlapping narratives? Is it logical and easier to seek clarity in the law? Does the law provide for answers, or does it just complicate matters further? Is the law a forum of liberation, or is it a forum of constraints and limitations of the way in which we understand trafficking and anti-trafficking actions? Now, to answer these questions, I think it is of paramount importance to define terms. So what does the law understand as human trafficking? The first internationally agreed definition of trafficking is to be found in the so-called Palermo Protocol, to the UN Protocol to Prevent, Suppress, and Punish Trafficking in Persons, especially women and children, which supplements the UN Convention Against Transnational Organized Crime. Now, Article 3 of the protocol defines trafficking as the recruitment, transportation, transfer, harboring, or receipt of persons by means of the threats or use of force or other forms of coercion, deception, abduction, fraud, abuse of power or of a position of vulnerability, the giving and receiving of payments or benefits to achieve the consent of a person for the purpose of exploitation, which shall include at a minimum the exploitation of the prostitution of others, sexual exploitation, forced labor, slavery, servitude, removal of organs, etc. So you have the full definition on your screens. I will not read that verbatim. But commonly, we refer to the Palermo definition as including three elements: acts, means, and purpose. So they're defined and divided as such in the slide you see in front of you for ease of reference. Again, we must have an act, one of the recruitment, transportation, harboring, receipt. So one of these elements, one or more, have to be present. Then we have means that are used to achieve consent. And then we have purpose. The first thing that is important to note is that exploitation doesn't need to happen. It is the purpose of exploiting that is necessary to find that a situation is one of trafficking. So even if a person is recruited through deception for the purpose of exploiting that person, and the person is intercepted before the exploitation happens, that is still trafficking. So again, exploitation is the purpose. It is not something that has to be already present and happened. Then in addition to acts, means, and purpose, there are further elements in the definition that are core and that require a bit of a deeper examination. And among these, the first is surely the element of consent. So consent is crucial when we speak about trafficking. And we have already addressed a bit of consent in the context of myths and misconceptions. And we have seen that complete lack of consent is not the test that the drafters had in mind to assess whether a person is trafficked or not. But what does this mean in practice? So there is an important distinction to be made here between adults and children. So two different sets of rules apply, whether persons are over or under 18. So for children, consent is always irrelevant. In other words, that means that children cannot be considered to have consented to being recruited, transported, transferred, harbored, or received, the act element of the definition. So again, consent is irrelevant when a person is under 18. We could be opening up a discussion about how the age of a person is assessed, in particular in the context of international migration, absence of documents, absence of IDs, absence of personal data of an individual. How is the age assessed? And we can have maybe in the Q&A or in the discussion section a conversation about that. But going back to the definition, so for children, consent is irrelevant. For adults, on the other hand, there is an evaluation that needs to happen. So consent is relevant, and it only becomes irrelevant if one or more of the means have been used to achieve consent. So this means that if the threats or use of force, coercion, abduction, deception, fraud, abuse of a position of vulnerability have been used, even if there was initial consent to one or more of the acts, that consent shall be disregarded, and the person shall be considered as having been trafficked. So again, children, irrelevance of consent, adults, it is relevant, but only if no means have been used. Now, the practice of the past 20 years, meaning since the adoption of the Palermo Protocol, has shown that proving the existence of one or more of the means is particularly difficult. Not only in criminal proceedings, where the threshold, the burden of proof is higher usually, but also in the context of identification of trafficked persons outside the criminal sphere. Oftentimes, authorities will have to rely on the testimonies of potentially trafficked persons to make a decision as to whether there was consent and whether that consent was vitiated. So very often we will not have hard evidence of any of the means being used. So everything comes down to credibility, to witnesses, to testimonies being heard by authorities, and authorities to decide whether that witness, that person is credible. So in these contexts, societal and cultural understandings of agency and victimhood come into play, and they might act as facilitators of, or conversely, as a barrier to identification. And this is especially true with regard to gendered assumptions around agency and victimhood, whereby men and women are subjected to a process of gender essentialization, really, based on patriarchal assumptions around vulnerability, which result in women being perceived as in need to be rescued, but also untrustworthy or not credible, not coherent. And men being perceived as prima facie, so on the face of it, invulnerable or unable to be deceived or coerced because they're men. And again, masculine individuals in patriarchal societies are seen to have always full agency, or usually generally perceived to be as such. So the impact of both essentialization processes are detrimental to the identification and the protection of trafficked persons, who are often disbelieved and misidentified, especially when they do not fit a fictional archetype of perfect victims. They don't behave as victims. They don't have a story that matches with what state authorities think is a victim's story. But again, we can open up a whole conversation and we will come back to this a little bit later on. But what has driven this restrictive approach to the protection of trafficked persons? Does the issue lie in the law? Does it lie in the application of the law? As too much often, the answer is not a straightforward one as one would hope. So let's take a step back and look at the global anti-trafficking instrument, the Palermo Protocol, beyond Article 3. As mentioned earlier, the protocol is linked to the UN Convention Against Transnational Organized Crime. Now, if you hear the words Convention Against Transnational Organized Crime, already you might make a number of assumptions. So the dominant lens in the protocol is logically a criminal lens, which means that the focus of the mandatory provisions is the criminalization of the crime of trafficking. This is not necessarily and in and of itself an unwelcome news. It is extremely important that trafficking is criminalized in domestic legislation. However, it becomes problematic when it is accompanied by very soft provisions when it comes to protection and prevention. It also becomes problematic as the protocol focuses on offenses that are transnational in nature and that involve an organized criminal group. There are therefore two qualifiers to the type of trafficking that the protocol sets out to cover, at least if we interpret the protocol literally. So transnational trafficking and trafficking by organized criminal groups. So does this mean that the protocol does not cover, for example, internal trafficking or trafficking by individual lone traffickers? But not exactly. So over time, the interpretation of the protocol has expanded on the one hand to include these modalities, However, the lens has remained largely unchanged, unaltered. So it's still a heavily criminal lens. Some, including leading academics such as Anne Gallagher, have argued that this was the only possible way to make states adopt an anti-trafficking protocol whatsoever. If the protocol had been framed through human rights language, through a different lens, it would not have been signed and ratified by as many countries as it actually was. So the Palermo Protocol is one of the protocols with the highest number of ratifying parties. And again, it has been argued by Gallagher, but also by Wiley and other scholars, that this is precisely because of the narrow criminal lens and narrow understanding of trafficking and narrow scope of mandatory obligations. Now, these also, the criminal lens, the focus on a particular type of trafficking, also stems from the history, the pre-history of the protocol, which did not emerge in 2000 in a vacuum. Again, it has a history before it. This history started really at the beginning of the 20th century. We have in 1904 and in 1910, the first two instruments dealing with the partial substance of the phenomenon of trafficking in persons, even if they used a different language, and they didn't spell out a definition of trafficking. So let's focus on language first. Now, if you look at the 1904 and 1910 convention, do you notice anything peculiar about the language, even just in the title of the conventions? So both speak about white slavery, white slave traffic. The first international instruments dealing with trafficking, first of all, refer to the concept of slavery, and more precisely, they referred to the traffic of white females for immoral purposes. So again, plenty of qualifiers here. White, females, and immoral. So again, the morality discourse and lens that comes back actually comes at the beginning of the actual protocol in 2000. So in adopting the language of slavery, both instruments initiated a process of de- and re-racialization and gendering of the phenomenon of slavery in a way that before the 1900s had been unprecedented. So both conventions refer explicitly to the procurement of white women and girls rather than of persons for immoral purposes rather than exploitation. So the initial dimension of human trafficking was charged with a racial dimension, shaped to include just one biological sex and one type of exploitative purpose. Now, the focus on white women and girls and on sexual exploitation surely needs to be considered within the historical framework in which anti-trafficking norms initially emerged, where the international community was, and I quote, particularly agitated by reports of the time that white women and girls were being trafficked into prostitution in Europe and the colonies. So it came out of a narrow, particular, precise worry and concern. However, these formed the basis for the process that led to the Palermo Protocol. And we have some developments over the years. So the seeds of, for example, a gender-neutral understanding of trafficking can first be found in the 1949 Convention for the Suppression of the Traffic in Persons and of the Exploitation of the Prostitution of Others. So this convention is still concerned with only one type of exploitation, sexual exploitation, but it gets rid of the biological sex element on the one hand, and of the racialized element on the other. So a step forward in 1949, we're degendering or ungendering the anti-trafficking system. We are de-racializing, at least in the law, the provisions. However, again, still only concerned with sexual exploitation and prostitution. So we talked about definitions. Even in 1949, we do not have a definition of traffic or trafficking. There's a constant reference to slavery. However, this is seen as something different from slavery. So not quite slavery, something else, but something else which is not defined. And it is only in 2000 that trafficking finally is given a definition, and that exploitative purposes other than sexual exploitation are added within its remit. However, again, international law is fragmented. I think I've said that multiple times by now already. And the fact that no other exploitative purposes were added in the context of anti-trafficking law doesn't mean that they were not considered anywhere else. Indeed, the global anti-trafficking framework has always interacted with a number of other spheres of international law, as well as in more recent times with the regional anti-trafficking instruments. So for example, I hope you can see that it's written quite small, but there was a lot to put on this circle. So we can see 1926, League of Nations Slavery Convention, 1930, ILO Forced Labor Convention and Protocols. We can see international law broadly, so international human rights law, international refugee law, international criminal law, international humanitarian law, all interact with the anti-trafficking regime. We can also see after the adoption of the definition, after the Palermo Protocol, a whole range of regional conventions being adopted, ratified, and implemented, or entered into force at least. So we see the protocol to the African Charter on the rights of women in Africa. We see the Inter-American Convention that I mentioned earlier already. We see the ASEAN Convention against trafficking in persons, especially women and children, the Council of Europe Anti-Trafficking Convention, and the EU Directive on preventing and combating trafficking and protecting its victims. Now, these are examples. And to these, we have to add, so this is hard law. Then we also have a whole world of soft law, guidelines, interpretation, model laws provided by UNODC, by the OHCHR, by UNHCR, by the Red Cross, by, again, UN bodies, non-UN bodies, CSOs, states, coalitions of states, etc. So the history that led to the adoption of the definition we use today is a controversial one. It is a partial one, it is an ambiguous one, and it's one that is, again, charged. What is different today with respect to these instruments? What has changed in the way in which we understand trafficking? In other words, what are the new perspective and directions? So where is anti-trafficking as a system headed? We've already mentioned the slow move away from a number, yet not all, of the limitations in the early definition. So we have now forced labor included among the purposes of exploitation. Certain regional instruments also include forced criminality among the purposes of exploitation, which is particularly interesting and important to have in the context of the trafficking definition. Now, this is the case explicitly in the Council of Europe Convention against Trafficking. And I'm always very happy to have a conversation maybe later about the interaction between the addition of forced criminality as a purpose and the implementation of the non-punishment principle in the context of anti-trafficking, which I will not discuss in the presentation, but we can pick up on later. So we have the inclusion of different types of exploitation, different types of potentially trafficked persons. We also have courts and tribunals increasingly and consistently bringing human trafficking within the scope of pre-existing human rights law treaties. So even when we don't necessarily have a prohibition of human trafficking in a human rights treaty, it can be brought under, for example, provisions on the prohibition of slavery. Because again, even though I won't open up the discussion on how trafficking relates to slavery, trafficking has come to be seen as either a modern form of slavery or a subset of the slavery umbrella definition. So this was the case, for example, in the European Court of Human Rights context, where the European Convention on Human Rights does not mention trafficking at all. If you control find trafficking in the ECHR, you will not find it. What you will find in Article 4 is a prohibition of slavery and forced slavery. So as early as 2010, through the Rantsev case versus Cyprus and Russia, the court included human trafficking within the scope of Article 4, thus allowing the court to evaluate and assess states' responsibilities and states' behavior vis-a-vis trafficking. So positive obligations, negative obligations, the way in which states prevent, protect, react, and criminalize and prosecute trafficking was brought under the remit or domain of regional courts and international courts as well. So we do have, again, these slow but welcome opening of the trafficking definition and understanding to these new, or not new, but newly seen forms of exploitation and trafficked persons. However, at the same time, we have also witnessed, in particular in the last 10 years, an increasing weaponization of the anti-trafficking language and framework to justify, among others, restrictive immigration laws and policies, closure of borders or establishment of hard borders, restrictive policies on, for example, sex work, conflation between the phenomena of trafficking and smuggling. Now, in multiple frameworks or contexts where maritime migration, for example, became particularly relevant, we've seen certain rescue humanitarian actors being targeted and charged with either trafficking or smuggling offenses as a way to criminalize their actions, seen as, in a way, facilitating illegal or irregular immigration. And the language of trafficking was used to justify these measures. Even if, again, if one interprets the Palermo Protocol and anti-trafficking framework in good faith, this was never one of the potential outcomes of any preventative or protection measure against trafficking. Yet, again, the language has been strategically deployed and weaponized to serve a number of states' interests, again, especially in the last 10 to 15 years. Now, I would like to address a bit of the elephant in the room, really, which is what drives human trafficking in the first place. So we've seen definitions, we've seen tensions, we've seen conflations, we've seen the way in which different stakeholders understand and narrativize really human trafficking, but we still haven't really looked at what drives its existence in the first place. Now, the discussion that has happened since the establishment of the Palermo Protocol has been one centered around root causes which later developed into one centered around risk factors. Now, some of these are globally recognized and accepted as root causes of trafficking. I know that poverty was already mentioned in the context of the introduction as one of the root causes. Clearly, we have trafficking related to conflict, political instability, breakdown of the rule of law, natural disasters, human rights violations, inequalities, including gender inequality. We also have corruption, discrimination, social exclusion. And we're seeing increasingly climate change. But again, increasingly, trafficking is linked with the impossibility of accessing either sustainable well-being on the one hand, which might again be linked to social exclusion, discrimination, poverty, lack of access to education, inequalities. But on the other hand, insofar as international trafficking is concerned, a lot of the risk factors are actually associated with the lack of access to safe and legal migration routes. So the closure of borders, which makes it harder for individuals to leave a situation of, for example, conflict, natural disaster, political instability, social exclusion, marginalization, and poverty, makes it easier for individuals to fall under conditions of extreme vulnerability. And it is in these conditions of extreme vulnerability that traffickers find it easier to deceive, to coerce, to threaten, and to achieve the consent of individuals to being, again, recruited, transferred, harbored, received, moved to a situation where they will be exploited. Now, the conversation with regard to the role of borders, the role of restrictions to migration, because again, we're talking about transnational trafficking. And common myth and misconception, most trafficked persons never consented to any of the acts in the first place. Again, lived experiences counter this narrative. The majority of individuals that are trafficked did at some point consent to at least an initial contact, an initial act of either recruitment or transportation. Why did they consent? Clearly, if the means have been used, the consent is irrelevant. But the why is important. Again, it goes back to root causes and risk factors. A person might consent because a job is offered, an employment opportunity, an income promise, the promise of migration to a third country where standards of living are better, the promise that family members will be taken care of. Then clearly we have then the more subtle, the more manipulative means. Oftentimes this will be a befriending, a boyfriending or girlfriending in the context, for example, of sexual exploitation. It is quite a widespread tactic that is used by traffickers. We have abduction, which by definition cannot be consented to, right? If I'm abducted, I can't consent to that unless I scheme my abduction for some obscure reason. But generally speaking, when a person is abducted, they don't consent to it. But I would like to focus on the elements that have a size or indicators of consent. And these are consent is driven by root causes. It is made stronger by risk factors. But again, acknowledging that there has been consent at some point during the trafficking experience doesn't mean that the person hasn't been trafficked. And I think sometimes we shy away from recognizing agency and consent because we fear that that will be detrimental to the identification of trafficked persons. I think that acknowledging agency and consent is key if we want to really address what are the most important, impactful risk factors and root causes of trafficking in recent times. So I'm talking about the 2020s, I'm talking about the last 5 to 10 years, I'm not talking about 20, 30 years ago, where the situation was clearly very much different. So one word that we are constantly hearing more and more about with regard to trafficking is vulnerability. I myself have used it extensively in the context of this presentation. I use it extensively in the context of my academic and advocacy work. So vulnerability, if you remember the definition of trafficking, is already present in Article 3 of the Palermo Protocol, in particular in the context of abuse of a position of vulnerability as one of the means of the trafficking definition. And we do have some guidance from UNODC as to what vulnerability means. The UNODC, for example, in the context of their interpretative guidelines to the convention and to the protocol, speaks about different kinds of vulnerability. UNODC talks about personal vulnerability, situational vulnerability, circumstantial vulnerability, pre-existing and created vulnerability. So vulnerability as a word is a planet, is a universe of different types of vulnerabilities that might interact with one another, make one sort of compensate for other vulnerabilities, or deepen an individual's vulnerability to being trafficked. So we can have situations where a person is vulnerable due to personal characteristics. But we can also have situations where an individual is vulnerable due to the social context they inhabit. We can have situations where a person is vulnerable due to lack of state's protection. We can have situations where not just one person, an individualized one person is vulnerable, but a cohort of individuals is vulnerable because of structural determinants. But the question is, are these individuals vulnerable in and of themselves, or are they made vulnerable by the lack of resilience mechanisms? So there are mainstream theories of vulnerability, Martha Feynman being one of the leaders or lead thinkers in that context, that say that we as humans, because we are embodied in a body that is vulnerable, are by definition and by nature vulnerable ourselves. So everyone is vulnerable in the first place, for the simple fact that we are fallible, that we are humans. What does this mean? That we're all vulnerable in the same manner? Clearly not, which is when, again, vulnerability theories come into place. I'm sorry, I got distracted by a message in the chat. I will revert to that later. But vulnerability really is the key word here. So the use of vulnerability, and in particular personal vulnerability, neglecting other forms of vulnerability, has several implications. And if we look at the literature on trafficking, if we look at the way in which government, stakeholders engage vulnerability, oftentimes we will find that the only or the mostly talked about and used is personal characteristics. Individuals are vulnerable because they are women, because they're children, because they're poor, because they're uneducated, because they have some form of disability, because they do not have a job, because they are in an irregular situation. The focus is the characteristics of the person. However, I believe that over focusing on the personal and ignoring the structural is problematic. So first of all, the focus on personal vulnerability places the onus and responsibilities of trafficking and risk factors on individuals, rather than structures, rather than systems in which the individuals exist. Secondly, it has deep gendered implications. We've seen these already before. I will not repeat elements of gendered assumptions, but the context remains the same. And third, it is problematic because it constitutes a tool of exclusion. So victimhood, if we understand it as the other side of vulnerability, can be understood as performative. And because decision makers acknowledge as vulnerable what they see or perceive to be vulnerable, according to their standards, some individuals don't readily fall into this vulnerable category. So if we only look at characteristics, we will have people that will be met with an assumption that they're not vulnerable in the first place. So without expanding on the mainstream theories of vulnerability, myself and other scholars have been arguing for a shift of focus towards relational and state-sponsored vulnerability. Indeed, while the risks of being trafficked and vulnerability to trafficking are surely to be found within the individual's distinct identity, because even though we're all vulnerable, some are more vulnerable than others, structural vulnerabilities shall not be ignored. And in particular, I would like to focus on the concept of state-sponsored vulnerability, bringing also the lecture to a close, which brings reflections on state responsibility into the socio-legal sphere. And in order to understand these continuum, the analysis that I will propose to you takes into account direct and indirect tools of state-sponsored vulnerability. But I would just like, before I do that, to go back a second to the law we talked about. So the Palermo Protocol contains, as I mentioned already, very little positive obligations on states in terms of, again, prevention, protection. Now, even if regional instruments have gone beyond the Palermo Protocol and jurisprudence has expanded on positive obligations, we still don't really have a comprehensive presence of positive obligations on states, in particular to prevent and protect. And in this context, going back to state-sponsored vulnerability, I mentioned indirect and direct forms of this particular type of vulnerability. Among the direct forms, I argue, are, for example, restrictive immigration laws and policies, but also legal regimes that actively favor human trafficking, tied visa schemes, labor externalization policies, securitized borders. Can we understand these as risk factors or root causes? If a state has a system whereby individuals are sent abroad through tied visa schemes and have no way of exiting an employment relationship which is abusive, exploitative, isn't the state responsible for that? Shouldn't it be regarded as responsible for that? Now, there are not only direct forms, there are also indirect forms. And in these sphere, I argue, are states' tolerance of so-called legal black holes. So areas that are within the jurisdiction, but outside of the attention or the action of the state. So if the state knows about exploitative contexts and it doesn't act, is it responsible for those exploitative contexts or not? if the state actively uses vulnerability as a tool of exclusion in the identification and protection processes, does this make people more vulnerable? Some people, at least, more vulnerable. And does that indirectly heighten risk factors and contribute to further exploitation and further trafficking? So without criticizing the international anti-trafficking system too much, and the particular lens it uses, it is really important, I think, to be critical when we speak about the anti-trafficking system. It has led to improvements, that's for sure. It can be improved still. It can be improved through changes or switches or swifts in paradigms in particular. The criminal lens, the human rights lens are very much entrenched in an idea of individualism and individual people being responsible, either individual traffickers, individual trafficked persons. Organized criminal groups is as wide as really the web is cast. But then the question I would like to sort of leave you with really is, what about the responsibility of the state when it directly favors situations where human trafficking can happen, or when it indirectly contributes to the existence of trafficking by not addressing the phenomenon, by leaving, again, these legal black holes that are not tackled at all, where there are no policies, no laws, incomplete laws, misapplied or non-implemented legislation. So again, what is the responsibility of the state in these contexts? And I know I'm conscious of time, and I really would like to leave a bit of time for Q&A or discussions or feedback, comments. So I might just stop here, if that is all right, Ines?
Yeah, sounds good. And maybe, yeah, we can just share. And there are some, like, 2 questions in the chatting room that I haven't had time to read yet. Maybe if the student herself want to talk, maybe Alexandra, if you can talk, you can say it, or if not, I guess they don't have the camera. So one of the questions is, do you have statistics on how many cases of transnational human trafficking have been prevented, or how has been held, or who has been held responsible for these crimes, and what is the punishment for this type of crime? I bet in the context of Europe, I guess, because maybe these different countries have different regulations regarding this. I'm not sure about that.
Yes, it's the toughest questions of all times, in particular because, again, as I mentioned, data collection in the context of trafficking is incredibly problematic. It is not something that is easy to do. Models, algorithms that have been used to try and quantify trafficking have elements of ambiguity, have elements of assumptions that one can accept or can contest, but they are not really precise. So you're talking now, Alexandra, in particular about transnational trafficking and prevention. So this is an area where there's almost no data at all. We have data on prosecutions. We have data on identification, but data on prevention, I wouldn't even know where to start in the context of compiling that evidence. How do you quantify how many people you've sort of taken away from a position of either vulnerability or a position where they could have been trafficked? Now, when we think about prevention, and I would really like to open the conversation up in the context of, when we think about trafficking, let's not just think about trafficking. We've talked about root causes and we've talked about risk factors. Talking about housing is talking about trafficking. Talking about access to healthcare is talking about trafficking. Talking about education, employment, labor's rights. All of this is talking about trafficking. Children's safeguards. So I would like really to open that discussion up. And I think that in particular, when we talk about prevention, it would be really interesting to look at whether healthcare, education, housing policies, do they include elements that relate to anti-trafficking? Are they aware that a sound housing policy, a sound labor code, a sound, again, access to healthcare policy has repercussions, has consequences on anti-trafficking action? And I think that in most cases, in most countries I've worked on, especially because I don't know everything, and that's all right. It's I think sometimes we have to accept that. But in the countries I've worked on, all these areas are very much siloed. So housing only only speaks to housing, and maybe just a few niche other areas, but there's never a comprehensive and coherent connection between all these spheres and the sphere of trafficking. And that's where the prevention lies. It's in those areas that speak directly to so-called root causes or risk factors. So if we want to quantify prevention of trafficking, I think we should quantify how many people have had improved access, again, to just name three: housing, education, and healthcare. I think that's where part of the prevention lies. And the other part of prevention, clearly, is on dismantling those networks that might be operating in specific jurisdictions. So dismantling a network might lead to the network not being operative anymore, which is in and of itself a form of prevention. And now I'm talking about things that can be maybe more easily quantified with respect to other elements of anti-trafficking action. Prevention, again, if a government implements a policy or an action, a trafficking action on awareness raising, that is in and of itself a form of prevention. But how do you quantify that? That's again the million-dollar question. And I wish I did have an answer. In terms of the punishment of the crime and who's been held responsible, the vast majority of cases who's held responsible is individual traffickers or networks of traffickers, but private persons. Companies, in some jurisdictions, we are seeing a slow but steady increase in terms of corporate responsibility. And these, again, it's not as advanced as it ought to be and as it should be, but we're increasingly seeing legislation being adopted in terms of business and human rights, which includes an element of trafficking and or modern slavery as well. So responsibility of businesses for trafficking their supply chains. And some companies have been found responsible for the crime of human trafficking and or human trafficking and forced labor, and have been convicted. Be that an administrative fine or criminal responsibility for particular individuals in the context of the company. What we still are not really seeing is state responsibility, is the prosecution of state actors when it comes to the crime of trafficking in persons. Very rarely have states been, or state officials being convicted of such offenses. And when they have, it was always a narrative of the so-called bad apple. It was never a structural, systemic approach to why the person has been convicted, who was allowed for the person to operate unpunished for whatever amount of time. issues of corruption are rarely addressed. And they're talked about a lot, but rarely addressed. And punishment, so there were lots of elements in this question. In terms of punishment, clearly there are international standards with regard to the model law on trafficking in persons. A person that is convicted can be convicted to jail time. On average, I might be mistaken, but on average, the sentence for private persons is 10 to 15 years, but there are aggravating circumstances. So if a large number of people have been trafficked, clearly jail time will increase. If the trafficking is of minors, that's also an aggravated circumstances, depending on the use of the means. But it really, really depends on domestic laws and each and every jurisdiction. So I can't really make a global analysis of that. Also, it's really hard to make a global analysis of that because data is rarely shared by courts. So we know about high-profile trafficking cases. We know about a number of landmark jurisprudence or judgments, but we don't have the full picture. And also, oftentimes, we have data that is on first instance courts, and then those cases are appealed, and maybe on appeal, the conviction is quashed. So data is quite unreliable. Just to go back to statistics, there have been efforts, regionally especially, to collect and collate data. There's a very interesting, let me find the link, a very interesting database that UNODC has, which is called Sherlock. And I can share that on the chat, where you can find trafficking as a category, and you can find landmark cases in a whole number of jurisdictions on a whole lot of exploitative purposes, type of victim, and so on and so forth. But again, these are partial efforts, very important, very needed, but also quite partial. I hope that answers the question.
It was very broad, very extensive answer to the question. I hope Alexandra got replied. In relation to prevention, I would like to ask also a question. You talk about vulnerability and how vulnerability makes people more susceptible to be trafficked and all this, get involved in this. And I guess some of these also include the countries where the people are trafficked towards, and also the countries where they are trafficked from. I do have in these countries common cooperation in order to improve the conditions of the people living in those states, so they are less vulnerable for being trafficked. That was my question.
Yes, again, very, very interesting points raised here. An area I haven't really discussed in the context of the lecture is bilateral agreements. So we do have clearly international framework, we have regional frameworks, we have domestic laws, but we also have a multitude of bilateral agreements between countries that have recognized or identified over time a significant flow in the context of trafficking between one another. And this might be a bilateral flow, like a circular flow, or it might be a unilateral one. So just to give you an example, in the European context, there are bilateral agreements in the context of prosecutions, for example, police cooperation between the UK and Albania, the UK and Vietnam. There are bilateral agreements about the return of trafficked persons. So the so-called voluntary repatriation, once a person is identified and is later on, with their consent, returned to the country of origin, between Italy and Nigeria. The vast majority of trafficked persons in Italy are from Nigeria, in particular from Edo State. So there are bilateral agreements in that respect. In the context of protection, I can surely mention some initiatives which tend to be more related to funding rather than cooperation agreements between so-called countries of destination and countries of origin, insofar as awareness raising is concerned, employment opportunities, which again can be problematic because they can be seen, rather than as an anti-trafficking tool, as a tool of effectively border control. So trying to prevent, in a sense, people from migrating from country A to country B through building opportunities in country A, which again, some might see as problematic. In the context of labor externalization, there are also a number of bilateral agreements. One that I can think about immediately is between, for example, Uganda and Kenya on the one hand, and Gulf countries on the other. In particular, in the context of domestic work, so bilateral agreements between embassies, that in the case of a complaint by a domestic worker from Uganda in any of the Gulf countries, the embassy will take responsibility for handling the case and returning or allowing the person to return to Uganda. Now, do they work in practice? Not entirely, but they do exist, and there are a multitude of them in all these different realms. So we have prosecution, we have prevention, we have protection. And they're increasing. The Palermo Protocol itself calls for more bilateral agreements and bilateral, be that memorandum of understanding or any other shape or format, but the substance is the same. What would be even more interesting, at least to me, to see is a source of bilateral efforts on research. So understanding why that nexus, understanding why certain countries are so deeply entrenched and tied with some other countries, but not the rest of them. So for some countries, that is quite, it has historical reasons, it has proximity reasons, but some others are a bit harder to understand and grasp. So it would be interesting to have more on that front as well, which in my honest opinion would also amount to prevention efforts. More knowledge, more research, definitely be prevention.
Okay, thank you very much for your answer. And we have also a question regarding to vulnerability from one of the researcher professors in our department, and it's called Chong Jong-min, and he you have mentioned situational pre-existing circumstantial vulnerability. And my question is about culturally recognized vulnerability as its so-called victimhood. People might prove themselves as victims, yet the idea of victimhood might be cultural, like depending on the cultural contents may differ. And have you ever come across these kind of cases? So,
absolutely, on a daily basis. So one of the biggest pieces of research has been precisely on vulnerability and victimhood, and how they are perceived, acted on, operationalized or bases, in particular in the European context, which is the context that culturally I'm able to understand better. And extensively, systematically, I see instances in courts and tribunals before competent authorities of people having to, as you say, prove themselves as victims. And in order to prove themselves as victims, they have to comply with the idea of victimhood that dominates states' institutions. So my research in particular has looked at adult men and trafficked adult men, which is the category that you almost never see mentioned in the context of protection, in the context of vulnerability. It's always the category that gets the least attention. And this is a cultural legacy. This is an historical, legal legacy, but it's also entirely a cultural understanding of vulnerability and victimhood that is based, again, in patriarchal assumptions. Now, I'm talking about Europe specifically, but some of these elements can be also taken and applied elsewhere. And if I do have a couple of minutes, I would really like to talk to you about a particular side of that. But in the context of Europe, and in particular the United Kingdom and Italy, there are assumptions grounded in culture whereby a victim behaves in a certain manner. A victim is weak, a victim is passive, a victim is traumatized, a victim is fully genuine, a victim doesn't lie. So there are elements of victimhood that are culturally entrenched that make it hard for stories that are not polished, that are not sort of rehearsed, or that don't fit that paradigm, to make it through the competent authorities, to make it through to identification and to protection. And again, I mentioned one of my main research pieces has been on adult men. And the other interesting element is that adult men are by default perceived as not only not vulnerable in the country of destination, but also not vulnerable in the country of origin. So oftentimes when individuals have, for example, a live immigration claim and they risk deportation, the language you will find in courts and tribunals is that the person, being an adult man, will not have any issues reintegrating into the country of origin. And I think this is extremely problematic because it applies standards of agency, vulnerability, and victimhood in one country to another without any cultural understanding of the country of origin. And I think that is one of the biggest issues when it comes to understanding vulnerability and victimhood in countries other than the one of origin. It can also be an issue within the same country of origin. And a whole parenthesis could be opened up here about the way in which exploitation even is perceived. So there are certain, with the British Institute of International and Comparative Law, we've just concluded a 2-year-long project on determinants of anti-trafficking efforts. And one of our case studies was Thailand. And in the context of Thailand, one thing that emerged quite clearly from our national research consultants was the idea of the inability to self-identify as victims in a context where exploitation is so widespread and accepted that it doesn't reflect what other individuals might perceive as being exploitative or exploitation. It is embedded, it is cultural. So a person doesn't see themselves as a victim just because exploitation is normalized. And this resonated in the Thailand case study, but also in Brazil, for example, when especially in the agricultural and construction sector, exploitation is very much the norm. And this then makes at least myself ask the question, what standards are we using, even internationally, to define exploitation? What is the language that international law has adopted truly inclusive or not? And unfortunately, my answer to that question is no. So the push for a different conversation to be happening about exploitation, about global inequalities in terms of access to opportunities, possibilities, markets, movement. These are the questions that critically ought to be asked. Now, clearly there are limitations in the context of the law. It can't be changed by critical theory, not yet, unfortunately. But I think that in these forums, it is really what I would like to see happening. this very critical approach to the law in and of itself, to the way in which it was created, formulated, maintained, enshrined, and implemented. I could, yes, go on a long time, but
thank you very much. I think we are done with the time, but if there's another last question.
Yeah, I have to ask one question, can I?
Yeah, you can.
Yeah, thank you, Dr. Noemi Maguliani. Sorry if I pronounced wrong. It sounds Italian. Well, I thank you. It's really informative for me. And we covered a lot of things, but in my opinion, maybe we have missed one, that begging. Like I'm from Pakistan, and from that narrative, if I see that begging and the begging mafia, that is really big one. And I know that UNODC have some more agencies like Europol, Eurojust, CIPOL, and Frontex. How they have worked and how many crime groups they have dismantled. Do you know about this something? One question. And second question is that in the world we see that highly trafficked humans are women, especially from 18 to 25 women, and then next is children. But if you go for West Africa, there is 100% that child kidnapping, child trafficking. The women trafficking is that on internet I didn't found. They said that only child are being trafficked in West Africa. What are the causes? In the world, it is like 80% or 75% women, rest is labor, forced labor, and children. In Africa, Nigeria and Africa, I guess 2 countries have that high rate, but especially in West Africa, it is only focused on like child trafficking. What are the causes? Rest of the world is changed, and that particular is changed. Thank you.
Again, thank you for the questions. I will start on begging, if I understood the question correctly. It is an area that can fall either under forced labor or under forced criminality. It depends. So if begging is criminalized, for example, in that case, it would be a criminal activity to beg. Therefore, if a person is trafficked to pursue that activity, then it would fall under the category of forced criminality and trafficking for that purpose. Now, clearly, these are fictional. I mean, not fictional categories, but categories that have changed over time and might change in the future. So I don't want to be too stuck to categories. But forced begging is a huge area. Data on forced begging was not collected until just a few years ago, and it still is very much not collected. It is made to fall either under the forced labor or the forced criminality category, but it's not disaggregated, which is the main problem with statistics. So what we were unable to understand precisely, if not anecdotally, how many people that trafficked individuals for forced begging are being prosecuted, how many networks are being dismantled, just because we don't have disaggregated data. So I could, again, mention a couple of operations that I know happened in the context through Europol, for example, in Italy, in Spain, in the UK, in Germany, mostly involving trafficking groups from Romania on forced begging. And this is just a European context, but these again are anecdotal. So there is no precise disaggregated data on how many networks have been dismantled, or how many individuals have been identified as having been trafficked for the purpose of forced begging. It would be, again, very interesting to build that database. But then the question becomes what? So to build a database and to do that in a way that is feasible, you would have to rely on media reports and court reports. Oftentimes, court reports are not available, or judgments are not even written. There are the case study on Guyana in the context of Bicol. Most of the judgments are not even written. They're oral judgments. How do you account for them? So there are a lot of complicated elements, but one could start from news media and available court reports. Then again, the question is what makes a news media platform, and why does it make that platform? What is the follow-up given to cases? But I don't, on data is really, really hard.
Yeah,
and I
teacher.
think the
Yeah,
question,
teacher. That I understand that part, but rest is that you and or DC, when there is no statistical data, how they are working. There are three agencies, four agencies like Europol, Eurojust, CIPOL, and Frontex. How many criminal groups they have dismantled in their history? Do you have some information about that? Some reports or something like that?
I do not have a full number of information. I know it's sectorally. So I know that Frontex, Europol, UNAV, Med have dismantled more than 70 networks in the Mediterranean when it comes specifically to trafficking in persons, regardless of the exploitative purpose. They argue they've dismantled more than 70 networks in the Mediterranean between 2015, and 2022. Have we seen 70 prosecutions? No, not yet. So either we take that as face value, or again, what do we mean by dismantling though? Is prosecuting, jailing, dismantlement? Or what is dismantling?
If you like you have captured something, or you finish it, or you end it, or you prison it, you have some conclusion, like finish.
Yeah, but that's what I'm saying,
Yeah.
If I say that Europol has dismantled 50 networks, I would like to see 50 convictions, 50 criminal proceedings brought against traffickers. You see what I mean? But it's really hard to square the circle between the narrative of how many networks have been dismantled and the actual prosecution and protection and convictions. So that link is missing, which makes me question, or at least not take lightly, the way in which Europol, UNODC, Eurojust, Frontex present their data. There is never a full process and circle.
Yeah, Professor, I understand that is long debate. Well, the rest why I was asking about West Africa, how and why it is changed beyond the on the side of the world, because in the world, women like 75 to 80% are trafficked women, and 20% is forced labor and children. But in West Africa, 100% is trafficked human are children.
I think she understood your question before. Maybe you can answer.
That was third question, Ines. It was not the same.
Third question. Okay, we don't have time for third question, I think, but maybe you can answer first to the second question that he made about the number of children trafficked in West Africa.
Yes, absolutely. And to organize the thoughts on that. Again, I would caution against taking those data at face value. I really doubt 100% trafficked children is the actual data. I know I might like a skeptic person or untrusting. Can you still hear me?
Internet problem. Hello.
There was an internet broken. Yeah, I can hear you now.
All right, good. Yeah, I saw everybody froze, and I thought I would stop talking if I was talking to myself. No, but I was saying that is the problem with making assumption based on disbelief that there's 100% of trafficking in West Africa that is on children. Now, there is a predominance of child trafficking in certain areas, including West Africa, and that's also a demographic element that changes, for example, between West Africa and Europe, where the population is generally older, where access to education is higher for children. Education is mandatory and is monitored up until 16 years of age. So if we take some of these elements, access to education, access to other basic services, then we can see vulnerability factors present that might sustain the argument that there is a predominance of that particular type of trafficking.
Okay. Do we have problems, internet problems again?
But I would caution again without condemning the nature of its collection. I tried to switch off my video now. I don't know where you lost me, but I just wanted to
mentioning the democratic factors of not having like a compulsory education system to 16, and this might be the factor that like kind of
and absolutely. And I just wanted to conclude on that just by saying that I think the question shouldn't be what does the data mean, but rather why do we have this data? Does that make sense? So if we're looking for explanations as to, oh, there's 100% children, why? I think the question should be, why is that the data? What is not being seen? I hope that's, I know it's a weird switch of question, but I would, again, just be really cautious about taking those data as face value, even the 75–80%. These are identified individuals, which doesn't necessarily reflect who is trafficked and who is not.
Yeah.
But surely in that context, West Africa, it's demographics, access to education, retention of education. These are some of the areas that explain, in a sense, a higher trend or pattern in child trafficking.
Can I ask my question again?
Oh, yeah, you can ask your question, and maybe this is the last one.
Yes. Do you have plan to do research on the removal of internal organs from wounded soldier, for example, in Ukraine? Because this topic is very sensitive nowadays. Thank you.
You're welcome. So on the topic of organ removal, there's a couple of caveats to be said in the beginning, though. So removal of organs and organ trafficking is a separate element. So there's a separate convention on organ trafficking. What is different is whether the person is, again, any of the acts, any of the means for the purpose specifically of removing organs. So if the organ removal happens without that process, if it is sort of incidental, or if it is not the purpose for the recruitment or the transporting or the harboring, then it doesn't fall strictly within that definition of human trafficking. It falls under a separate convention, separate sets of rules. However, because it has been increasingly reported, there has been more and more interest into looking at whether certain individuals are specifically targeted for the purpose of organ removal, which would make it fall under a human trafficking definition rather than organ trafficking. I'm not doing personally any research on that. I did research on trafficking for the purpose of organ removal in Libya, but I'm not doing that on Ukraine. I do not necessarily know about someone who's looking at that through the human trafficking lens. I know about the organ trafficking lens. There's a few people working on that. I don't know the human trafficking, but I will absolutely inquire with that. And I know it is something that the Special Rapporteur on Trafficking in Persons has raised as a concern when talking about when discussing Ukraine and the trafficking situation, both outwards but also internally. I'm sorry I can't be more exhaustive than that, but thank you for raising the question.
Thank you very much.
Thank you very much for your lecture. I think it was very interesting and it raised many questions. Actually, not many questions it's raised in every lecture. So it was really glad. And thank you very much for your time in the lecture. And it's been very interesting, especially to talk about vulnerability and how many other factors have to be taken care of, not just looking on the trafficking act itself, but there are many underlying conditions that should be treated before and during all this, looking at the issue. And thank you very much. And I think we will stop here the lecture. Thank you.
Thank you very much for having me. And I'm happy if you want to share my email address with the participants, if they have any questions or want to connect, I would be very happy to do so.
Sure, maybe we can write it here in the chat
I will
room
do that.
so they can take note of it. And yeah. So thank you very much for all of your time, and I think it's very early in the morning for you.
It's all right. Thank you, everybody. It was lovely to engage with you.
Thank you. Bye.
Bye-bye.